Inshallah, we are beginning our follow-up session on the What's in Your Will iMuslimah halaqa, which was held a few weeks ago, alhamdulillah, and we had almost 200 questions that came from our attendees, which we were not able to answer due to the time. So we decided, for the benefit of the community and for all of our guests and attendees, that inshallah we'll have a follow-up webinar, which is today, with Dr. Sheikh Ahmad Abdelwahab and our attorney, brother Siraj Sohail, and they are here on this webinar today to answer all of those questions. So inshallah, this will be a wonderful learning experience for everyone to see how to practically deal with these issues that all of us are facing regarding our wills and our planning. And inshallah, you'll have an opportunity also to ask some follow-up questions in the question box at the bottom of your screen. So we welcome all of you and thank you all for coming. And inshallah ta'ala, I'm going to go ahead and start this webinar by introducing our dear and respected Sheikh Dr. Ahmad Abdelwahab. And just by way of introduction again, Dr. Ahmad Abdelwahab is a graduate from the Islamic University in Medina, where he did his bachelor's in Sharia and his master's in fiqh, with an emphasis on in matters of inheritance. And he went ahead and, mashallah, completed his PhD last year in fiqh from the same Islamic University of Medina. He has studied under many scholars. He has ijaza in the recitation of the Quran, and he also is the founder of Lisan al-Arab Institute, which focuses on teaching Arabic to non-Arabic speakers. So without further ado, inshallah, I'm going to get into these questions here. And we're going to start with the Sharia questions, or the fiqh questions on Islamic and the inheritance law. And then we will go, after all of those questions, we'll go into the aspects of the US legal law with Brother Siraj. So I will read the questions, and Sheikh Ahmed, you can go ahead and answer them. And when you've completed your answer, you can just give me an indication, and then we'll move forward to the next question, inshallah.
Sure.
Sounds good?
Sure, sounds good. Bismillah, alhamdulillah, wa salatu wa salam ala rasulillah wa ala alihi wa sahbihi wa mawala. Welcome everyone. Inshallah, may Allah make this beneficial gathering and give us beneficial knowledge and good actions.
So the first question for Sheikh Ahmed: my father passed away 20 years ago, and my mother was the owner of all of his wealth. We are 3 sisters and 1 brother. 19 years later, my mother passed away without a written will. Now, should we consider the huge amounts she spent on my brother some money she lent him with our consent as part of his share? Now, the brother claims that the mother, she forgave him, although she claimed it back in my presence.
Okay, Bismillah. The first thing, the question says, my father passed away 20 years ago, and my mother was the owner of all his wealth. The mother was the owner of all his wealth. That only can happen if the father gifts the mother all of his wealth during his health. So he tells her, I give you all of my money. And then he does not own anything. However, he cannot, at the time of death, just say, this is your wealth on his deathbed, because it takes the rulings of a wasiyah. So a person on their deathbed, they cannot give their wealth. During their health, he can give his wealth to his wife, but she would own it then, and he wouldn't own it. So normally it would be the wealth should be inherited, where the mother takes 1/8 since there are children, and the 3 sisters and the 1 brother take their share. للذكر مثل حظ الأنثيين, 2 shares for the brother and 1 share each for each sister. Each sister will have 1 share, assuming that these were the people who are alive during the death of the father, and assuming there's nobody else. There might be other people who inherited, for example, the mother or the father and so forth of the deceased. So the first thing is that we want to make sure that the money that the father left was inherited properly, unless he got rid of all of his money before his death during his health and he gave it all to the mother. In this case, he would own 0 and the mother would own all of his wealth. His wife, which is the mother of the children, would own all of his wealth. Now, if the children who were adults and sane allowed the mother to take all the wealth and not take it as inheritance, each person has that right to forgive part or all of their share. So 19 years later, my mother passed away without a written will. Should we consider the huge amount she spent on the brother part of his share? It does not work that way. We have to see first if he left inheritance, then there's no way for the mother to have all of the wealth. That means each child had their own set of wealth, and then either the mother could spend on her children from her own wealth, or the children can be spent on from their own share. So this question is not very clear, and the problem is it's not clear how the mother gained all of this wealth. And when she spent on the brother, was she spending from his wealth, from his share, or from her own money? And this is the problem one. Things are not clear from the beginning. So in Islam, there's no such thing as my mother owned all of his wealth. How? It's his wealth. Did he gift it to her? Did he say all of this is yours? Or did she automatically assume that she has the right to all his wealth? Because Islamically, she does not have the right to all of his wealth. So I would suggest for the family to get together and go to a local Islamic scholar and student of knowledge and imam and explain the situation completely with everyone present, so that they can understand the full case and give a ruling accordingly. Barakallahu feekum.
Okay, the next question. Is it allowable for a husband and wife to consider everything they own to be owned by both? Is it allowable for them to consider everything to be owned by both husband and wife and all the children?
In general, a person who owns something is allowed to make another person a partner in it, but that has its rulings. So, for example, if a person owns a car and they sell it, they own all the money that's made from the car. But if he makes another person owner, let's say his brother, he says, I'll give you half of this car. You own half of it with me. He's allowed to do that. Or he tells his wife, you own half of the car with me. He's allowed to do that. If the car is sold, then they will share it. So it's a partnership. And it's allowed to be done even without any investments. So a person can purchase a house or purchase a car, or gain $100,000, for example, and say, I want to split this with others from my family members, and they will own a share from it. It must be known, and this is a sort of tamlik, where you give somebody else part ownership. It must be known who now owns this item and how much are you giving them from it. Are you giving them 50%, 25%? This must be clearly known, so that if there's any issues, everyone knows their share in everything. So if a person wants to split property or anything else with their wife or their children, it needs to be known. If it's with children, it needs to be done equally with all the children if it's a form of a gift. The majority of scholars say they should be given equally, and the Hanabila, the school of Imam Ahmad, says it follows the rules of inheritance. If you gift your children, it follows the rules of inheritance. As for your wife, you can give her all of your wealth, but then she owns it. So, for example, if there was a divorce, she owns that wealth. You can't say, I changed my mind. When property and ownership is something very something very legal and very strict, and it has its rules. Because if something gets damaged, who's the one who pays for it? Who's the one who has the ability to sell and to gift? It's the owner. And there are a lot of rules related to that. So be careful when you say I share, I give my wife, for example, half of this house, or my children, I split this house amongst them equally. Then there are rules to that. One child can no longer gift that house or sell it on his own, because now there are partners in it. Wallahu a'lam.
Okay, the next question. My mother gave me certain land in papers on my name. My brother too was present at that time and he had no issues. The next day she passed away. Now should I pool in that land along with other properties to be shared between my siblings, or is it only mine?
Now, in general, we just said that children, and a parent is not allowed to give one child a certain gift, whether it's wealth, land, car, unless they give all their children equally in their life. And as we said, either they follow the majority opinion where they give all the children equally, or the Hanbali opinion, which says you give according to the inheritance, where the sons get 2 shares and the daughters get 1 share. So in this situation, where she gave land to the daughter, if it was during her deathbed and she knew she was going to die, this would not be allowed, and it would be considered inheritance, because otherwise anybody on their deathbed, they can prevent their children, one child, and just start gifting to other children. So if it was during the deathbed, it would take the hukum of a wasiyah, which wouldn't be allowed here, and it would be considered inheritance, except in the case where all of the inheritors don't have an issue with this. So if it was during the deathbed, it would take the hukum of wasiyah, basically 1/3 to non-heirs. And if it was given to one cannot at that time give to people who will inherit them, and it will take the form of the rules of inheritance. However, if it was during her health and there was no fear of death, and it wasn't during the deathbed, and the mother gave certain property to a child because they needed it. For example, one child was rich, and they had, for example, land and property, and the other one was poor and they needed something. In this case, it would be giving a child what they need. So it wouldn't be an issue if it was from, if there was no oppression in it. Because one child, for example, is well off and has everything they need, and the other child is in need of something, some land to live on and a house to live on and so forth, while the other children already have these things. In that case, it would be permissible if it's something that child specifically needs. In general, if it was during the time of death, it should take the ruling of inheritance, and the people who inherited should inherit that property accordingly. Wallahu a'lam.
Okay, before we go to the next question, I just want to tell all of our respected attendees that this session is specifically for the questions that were asked in the last webinar. And the questions that we will try to answer in the question box where you can type are first and foremost questions that pertain to these questions that we're answering on the screen. So the follow-up questions, just so you can understand the answers of Sheikh Ahmad and Brother Siraj. So any new questions regarding unrelated matters, matters related to, not related to the questions that are on the screen, those are going to be the lowest priority, unfortunately, just because due to the time. So please try and restrict your questions that you put in the question box to these answers that Sheikh Ahmad and Brother Siraj will be giving, inshallah. So more questions for clarification. Okay, the next question here. Can my husband tell me not to spend the share I get in the event of his passing on my mom or my siblings?
Once a woman gets her share of inheritance, she is allowed to spend it as she wishes. Her husband cannot tell her to not spend on her mother or her siblings. The only thing is that the wife cannot spend from the husband's money without his permission unless she knows he does not mind. So a woman who owns her wealth is free to do what she wants with it as long as she follows the legal Islamic rulings. And this is not correct for the husband to not allow bir or being good to one's mother or siblings, or to say, no, give it to my own mother and siblings. This is not correct and this is not fair. However, for example, if he can advise her if he's seeing that she's not spending, she's spending too much on things that she should give priority to other things. That's something else in terms of advice. As long as she's following Islamic rulings on her wealth, he cannot tell her, do not spend on your mother or your siblings. Allahu A'lam.
Okay, the next question. My mother passed away. She didn't want any of her jewelry to be given to her son and his wife after her death. Should the daughters comply to her will? Is this Islamically right?
Okay, jewelry is part of a person's wealth. So if a person dies and they have jewelry, it is to be split amongst the inheritors. So it can be, for example, the inheritors can agree to sell it and split the cash, or if it's a type of jewelry which is all the same and can be split evenly, that's fine. Otherwise, they all have a share in that jewelry. So it would be the son would get his share and the daughter would get her share, and the son's wife does not inherit. But if the son inherits his share, he's allowed to give it to whom he wills. He can give it to his wife, to whoever he wills to give it to. So jewelry is part of the person's estate and wealth. Anything, books, cars, jewelry, there's all a person's wealth that nobody can. Once a person dies, it automatically goes to the inheritors after paying off the debts, funeral expenses, debts, and the wasiyah.
Okay. Next question. I have heard that property cannot have two owners Islamically, so the one house would have to belong to just one. Is that incorrect?
Yeah. No, Islamically, there can be ownership. People share in a house or a car or anything. Either they both purchase one car together, for example, and they pay 50-50, so they'll own it 50-50. Or a person can own a car and say, I give you ownership of half of it out of his own goodwill, then that person would own half of that share. Or two brothers, for example, whose father passed away, can inherit the house and they will both own it 50-50. So the property can have many shares and many people owning it.
Okay. Next question. If non-Muslim parents leave you money, can you use it for their funeral expenses? Is it okay to donate it to a masjid or something like that?
So in terms of the non-Muslims, if they leave the parents, then they leave behind an estate, you, you're allowed to take from it as a wasiyah up to 1/3. However, if they leave it for you, yes, you can pay for their funeral expenses and you can pay off their debts from it. And if they give it to you as a will, you're allowed to take up to 1/3 of it as a wasiyah. But a Muslim does not inherit from a non-Muslim or vice versa. And if they did not leave it to anybody else, they did not tell you what to do with the rest of it, yeah, you can donate it to, if they left it for you and there's no, they don't have people who inherited them. Yeah, if they come to us, the non-Muslims, for inheritance, that the laws of inheritance basically say that we do not take except 1/3 of as a wasiyah. Allahu a'lam. So if there were other siblings, for example, and they come to you, you would split it according to Allah's law. Otherwise, they split it as they wish in their religion. But as a Muslim, you can only take up to 1/3 as a wasiyah.
Okay. The next question: can material belongings like jewelry, cars, etc., can these things be written in the will to be given to whoever wants to have them?
Jewelry, cars, and all those items are part of a person's estate and wealth. As long as they can be sold, it's a wealth. It's a type of wealth, and as long as it has halal value, and halal, something that's halal, and it's not like, for example, alcohol or something like that. So this is a type of wealth and type of property in Islam. So it's part of the person's estate. And even if it needs to be sold to pay off debts, they will be sold. So a person can only give 1/3 of what remains after debts to a non-heir, a non-inheritor, and the rest would be split amongst those who inherit that person, whether it's a car or jewelry or any other item.
Okay. The next question: if you have retirement accounts and you get RMD 4% annually, what is this? Return on I'm not sure what RMD is, you'll have to forgive us. Annually, the remaining money stays in the accounts. How would these be distributed according to Islamic inheritance law? If anyone knows what is RMD, please chat it.
I looked at this. This is an issue of as long as a person is getting a halal in return, if it's a halal return, yeah, and it's permissible, then it's part of their inheritance. Anything that comes after death would be inheritance. So somebody, let's say they invested in a halal stock and it keeps making money, the shares would be owned by those who inherit that person based on Islamic law, and that money would they would be would take over their share of that account and so forth.
Sheikh Ahmed, our guests are, many of them are saying RMD is required minimum distribution.
Okay, so I'll just give you the general ruling regarding that. I would have to look more details into the RMD. So I'm just going to give you a general rule regarding investments and retirement funds. If the investment fund is halal and the profits are coming from it are Islamically allowed, then once a person dies, those who inherit him will inherit that money and what comes from it as profits, and they would be partners in it, as according to the way that Islam splits that money. However, let's assume that the investment was haram and the money coming from it was haram, either wholly or partially, then taking that money would not be allowed, and the people who inherit would need to get rid of the haram profits and try to stop that investment and either put it into a halal investment or just split the money that's halal from it. So let's say, for example, a person puts in $100,000 in a riba account and they die. So now this account brings in, for example, 10% interest or 5% interest or whatever percent interest. Now those who get that money from the inheritors, they should only take the halal money from it and get rid of that haram money. They can give it to the poor, but it's not a sadaqah, it's getting rid of haram money. And they should figure out how much that is and get rid of it and ask Allah subhanahu wa ta'ala to forgive that person. So in general, any returns on any investments, you look at it that way. So regarding the RMD specifically, we'd need to look into that to see if it's halal or not, this type of return. And I cannot do that right now.
Okay, next question. A sister is divorced with young kids and her ex-husband and brothers do not provide for her. As her sister, can I leave her more than the prescribed amount?
Okay, a sister, if she's going to inherit, she only inherits what she's allowed to inherit. And if she's not going to inherit, a person can leave up to 1/3 for their siblings, either brother or sister. So it depends on the case where, for example, the person who wants to give, if she has children, for example, if she has a son or a father, the sister will not inherit in this case. So she can give her up to 1/3. But if she does not have a son or a father, and let's say she only has one mother and one sister, here the mother would, for example, take 1/3 and the sister would take 1/2, and it would be split according to basically the Sharia. So she can only leave as a will to her sister up to 1/3 if that sister does not inherit from her. But if she inherits from her, she's only allowed to take what her share that is in the book of Allah. Likewise, she's allowed to gift her what she wishes during her health, and she can spend on her and her kids during her health, and so forth. So there are different ways she can help her sister. Wallahu a'lam.
All right, next question. There is a single mother. She is the one who is the head of the house. Can her family give her 1 or 2 because she is the breadwinner? Maybe she means 1 or 2 shares.
In terms of the shares of inheritance, that does not change regardless of if how much the person does for the family. So whether the father, for example, or the son, they might be in a wheelchair and unable to work and earn income because they have some medical issues. That person might even be, for example, have some mental issues or is insane and does not, and so forth. That has nothing to do with inheritance law. Inheritance law, the child who is 1 month old and the child who's 80 years old are the same. And whether that person makes a lot of money for the family or little money for the family, it doesn't matter in terms of inheritance law. The inheritance laws are set, and we mentioned that the wasiyah is for non-heirs up to 1/3. And as for spending or gifting, then that has a whole different chapter in Islamic law.
Next question. If a deceased father passed on a property that is used for rental income and one of the inheritors would like to continue to use it as an income property, collect rent, not sell it, does this person need to pay a monthly amount from the rent to the other inheritors?
So basically, if a person the father left behind the house that he was renting to others, all of the inheritors will own that house based on their shares in Islamic law. So let's say there are 3 brothers, to make it easy, 3 sons, and nobody else. Each of those sons will own 1/3 of the house. So they can agree to continue renting that house to others, and let's say it makes $6,000 a month. Each of the sons will take from that rent their share, which is 1/3. And if there are expenses on the house, let's say, for example, the house needs some fixing or for the bills to be paid on it and so forth, then they would share also in the expenses based on how much they own of the house. Now, if somebody wants to sell their share or they want to all sell the house, that's a different story. But in general, they can continue renting the house, and uh, they would need to share the profit from it, what they gain from the rent, amongst themselves, and they would also have to pay for the expenses amongst themselves, all based on their share in that house based on inheritance law. Allahu A'lam.
Okay, the next question. Before passing, a grandmother bequeathed a small amount of gold to daughters of the deceased daughter, meaning her granddaughters, right? Since there would be no other inheritance, the other kids do not honor the request because they say that Islamically inheritance just goes to kids that are alive, regardless what the grandmother said prior to passing. Is this true?
Now, if the grandmother during her life she gave as a gift, she's allowed to give as a gift to her granddaughter. Now, and the scholars differed if she has to equate between her grandchildren or not, but that's only for the children, wallahu alam. So now, if she left it in her wasiyah, that this granddaughter will get certain jewelry, as long as it's up to 1/3, and that granddaughter is not inheriting from the grandmother, then, which is her daughter's daughter, then in that case, she would be allowed to take that jewelry as long as it's up to 1/3 of what remains after paying off her debts. And the rest, what remains after the wasiyah, is considered inheritance for those who inherit Islamically, like, for example, the direct children and so forth.
Okay. Next question we have. If husband, wife, and son and the father passes and the mother collects monthly money from the father's retirement, does this monthly amount get divided Islamically with the son also?
Yeah, technically, any money that comes from retirement funds is considered inheritance. Inheritance for the children and for example, the spouse and the parents. Any money that comes from a person after their death from an earlier investment and so forth is considered inheritance. However, if the company, for example, wants to honor the employee's, for example, wife or spouse, and they want to give them from their own earnings something, that's different. But any money that a person owns and is in their name when they die has to go to those who inherit, unless a person does a waqf, an endowment for non-heirs, or if it's for their heirs and children, it would follow the rules of the wasiyah, of inheritance. Allahu Alam.
Okay, the next question. Can I gift my portion of my house to my wife, and can she also do that?
If you want to split, you purchase the house and you want to split it with your wife and give her 50% ownership or 25% ownership, you're allowed to do that. Just make it clear so that all the laws related to ownership are known in case anything happens to you or to your wife. So if you can give her whatever portion you want of the house, you can gift her the entire house if you want, and she can also do the same. But it follows the laws. For example, if you say I give you ownership of half of that half of the house, then if you sell the house, she owns half of the money made from that purchase.
But Sheikh Ahmed, can you clarify that you can't do this gifting to circumvent the inheritance portion?
Right. If you're during a person's health, they're allowed to gift, for example, to their children, or to if they're just amongst their children, and they're allowed to, for example, give ownership of half of the house to his wife, but then she'll own half of that house technically. And if she were to sell that house, it would be half of it would be hers, and half of the money made from it would be hers. However, a person is not allowed to start gifting before their death to prevent those who are inheriting. So, for example, they're on their deathbed, and they don't want, for example, the wife to inherit, so they'll start gifting. For example, he'll start gifting all of his property to his brother, for example, so that the wife doesn't get it, or she might do the same for the husband, so that the husband does not get it. This would not be allowed, and this is why in Islam, once a person is on their deathbed, they're not allowed to. Any gifts at that time will take the rulings of the wasiyah. Only 1/3 would be allowed to non-heirs, and anything that goes to heirs would not be allowed, and it would be just considered without the acceptance of all the other people who inherit, and it would be considered like inheritance. There's a whole chapter on that regarding gifting of a person who's on their deathbed. But once a person is healthy, they're allowed to gift whatever they want, as long as they, if it's their children, they have to be equal, give gifts equally to their children. Allahu Alam.
Jazakallahu khairah. Next question. I want to gift my minors equally a condo that I own. How can I do this while alive and avoid paying a lot of money, since this will not be Sharia compliant after death?
Basically, if you're talking about gifting your children an apartment or a condo or a house, you can do that, but based on Islamic law, either they will all get it equally, according to the majority of scholars, or the Hanafi say 2 shares for each son and 1 share for each daughter. And the stronger opinion, Allahu Alam, is that during your life it should be equally gifted to all of your children. So if you do that, it would be Sharia compliant. As for legally how to avoid it without paying a lot of money, that's a legal question that we can leave for Brother Siraj. As for after death, it would be inheritance for all those who inherited.
Okay. Next question. If I want to give my 2 daughters my house and my 401k and other properties at my death, how can I do so following Islamic law? I am single.
So basically, you'd have to write a will where you know that who is inheriting from you. Right now, I cannot give you a full answer unless I know who is everyone in the family, basically. Let's say you only have 2 daughters, they would get 2/3 of your property. 2 daughters or more will get 2/3 of the property. If there's no sons, then we have to see who else is there. Is there a mother? Is there a father? Is there a male relative that would take the rest of the money, and so forth? So I cannot just, because a lot of people just mention 2 daughters and they don't know who inherits. So you would need to, I would advise you to get a counsel, for example, from mywasiya.com, and they can mention to you go through the whole process with them, so that you know who inherits from you, or you can ask somebody that knows your family, or you can explain to the whole process of who inherits. If it's just 2 daughters and there's nobody else that inherits, they would take it 2/3, and then basically the rest of it they would also split. That's assuming that there's nobody else who would inherit. Allahu A'lam.
The next question. My wife and I don't have children together. She doesn't have children of her own. As we understand it, I, her husband, get half of her money, and the other half is divided Islamically to her mother, 1/3, and remaining to siblings, 2 brothers and 2 sisters. Is this correct?
If a person dies and she leaves a husband and she has no children, and she leaves a mother and she has siblings from both parents, then yes, the husband would get half and the mother would get 1/3, and the remaining would go to the siblings, the two brothers and two sisters, 2 shares for each brother, and 1 share for each sister. So the remaining would be split as 6 shares, 1/6 of the remaining for each of the sisters, and 2/6, which is 1/3 of the remaining for each of the brothers, assuming there's nobody else that inherits. That there's, for example, no father, no grandfather, the father's father. So, yeah, as I said, we cannot answer these types of questions unless we sit with the person and see who's a judge in a court case would have to know who are all the relatives that were there during the person's death, and how they're related, and if there's anybody else involved, and so forth, to make sure that all the conditions are met. But in general, if these are the only people, then this is correct.
Okay, the next question. Do brothers and sisters also inherit?
They inherit in certain cases. For example, if there's no son and there's no father, they will usually inherit, yes.
This means basically, does a brother, does a sister of a brother inherit, or vice versa? Right.
Right. The siblings can inherit from the deceased in certain cases, not in all cases.
Okay. Next question. When there are no inheritors, can one give the 2/3 to anyone, Muslim or non-Muslim?
Okay, so basically, a person, we said, has 1/3 to give as wasiyah. But if there's no inheritors whatsoever, and that's a rare case, then the money can go as all in charity or as a wasiyah. Uh, all of it can go as a wasiyah, whether Muslim or non-Muslim, assuming that there's nobody to inherit. But you have to realize that the general inheritance laws are flexible. Like if there's no relatives whatsoever, in that case, then they would not have inheritors. You just need to make sure that there are no inheritors. Even if your general inheritors aren't there, then there are dawil arham. So people that don't normally inherit would inherit. For example, the mother's sister or the mother's brother or the father's sister. Those or the daughter's daughter would inherit in such cases, uh, based on specific Islamic law. So yes, if there are no inheritors whatsoever, then a person can give all their money as a wasiyah after their funeral expenses and their debts are paid off.
Okay. Next question. Regarding spouses with joint ownership, for example, does the remaining spouse keep his or her 50% and the deceased 50% gets distributed according to Sharia? And do they need to contribute equally financially to the joint account?
Now, in terms of joint ownership of a house, for example, then what gets inherited is that person's share only. So if they split it with their spouse, then one remains alive and the other passes away. The one who passes away, their share gets split amongst the heirs and those who inherit. Now, if there's a joint account, like in a bank, for example, and the uh, husband gives the wife half of the account, half of the wealth, or the wife does the same with the husband, then if the person dies, half of that share, their share would be distributed amongst the inheritors after paying off the person's debts and taking care of the wasiyah. Now, do they need to contribute equally financially to the joint account? Now, really, it depends on what they agree on. If they say all the money we make is split between us 50-50, then it doesn't really matter how much each person uh, puts in, because they both agreed that we're going to split it 50-50. And then if they decide to end that, then each person takes their 50%, and then any money they make afterwards would be theirs.
Okay, next question. If you have multiple children alive and one passed away, For the deceased son, do his children have a share in the father's wealth?
So a person has multiple children and one of the children passes away, the son. For the deceased son, do his children have a share in their father's wealth? Or do you mean the father's father? So the children of any person always will inherit. And the parents will always inherit, and the spouse will always inherit. But the son's son will not inherit if there are sons. The son's son can inherit only if there are not sons. So, for example, if he left one daughter and a son's son, the daughter would get half only. Those are the only people he left, one daughter and one son's son. Then the daughter would get one half, and the son's son would get the remaining, assuming there's nobody else. So it really depends on the situation that you're talking about. But the son's son will only get if there is no son. If there is a son, the son's son would not get, and in that case, he can take a wasiyah, take from the wasiyah up to 1/3. Allahu A'lam.
Okay, the next question. My sister passed away during my parents' lifetime. She had 3 sons. My parents told her children if they want their share, they should keep it. Now my parents have passed away. They are asking for their mother's share. Are they entitled in Islamic law?
If they gave her that share and said you can keep it, and they forgave it, then whoever they gave it to, it's theirs. So for example, let's say there are a group of people who inherited and then they felt sorry for one of the inheritors and they needed the money and they're well off, and they say you can take our share, keep it, then that's basically tamlik. Tamlik is when you give somebody ownership of something. Once they do that and they take it, they acquire it, then they cannot take it back. This is why if you gave somebody, for example, $100,000 as a gift, you cannot change your mind after that person takes it. But before that person takes it from you, you can change your mind according to the majority of scholars. You can say, I changed my mind. But once that gift is given to another person, you cannot say, I take it back. So here he says, my sister passed away during my parents' lifetime. She had 3 sons. My parents told her children, if they want their share, they should keep it. The sons get her share right away, whether the sons will get their share and the parents will get their share. So the parents will get, for example, the parents here would get 1/6. The mother would get 1/6. The father would get 1/6. If she has a husband, he would get his share, for example, 1/4. And the 3 sons would take the remaining equally if there's no other daughters. Now, the parents told her children, if they want their share, they should keep it. Okay, that is their share, that is their money, that is their inheritance. Now my parents have passed away and they are asking for their mother's share. It's not their mother's share, it's their money. If they inherited that money, it's not as soon as a person dies, after paying off debts and the wasiyah, the inheritors automatically own their share, even if it's split incorrectly or they don't get to touch that money. It's theirs. It's Islamically it becomes theirs. Whether unless a person says I don't want it, I'm giving it to another person, then it's a gift. Are they entitled to this in Islamic law? So yes, the sons who passed away, they have full right to their inheritance. And as long as it's there, they have full right to it, and they should know how much it is, and it should be saved for them in their own account so that it does not get mixed with other people's wealth. So that their share is and their full right is preserved. Allahu a'lam.
Okay, the next question. Are the deceased personal items like clothing, books, jewelry, and shoes, etc., also handled the same way following 2-to-1 share?
Yes, it's considered estates or part of the estate and it's property. And they would have joint ownership in it. Now, what will happen is that they can all decide to, for example, gift it if they all decide to do that, or give it in charity, or they can decide to sell it and split the money made from it amongst them based on the inheritance law. So if they all have a car, let's say it's two brothers and two sisters, each one would have, for example, the brothers would have 1/3 of each, and the sisters would have 1/6 of the car. If they sell that car, they would split the money based on that share.
Okay, next question. What happens to the only house left by the deceased if his wife and children are still living in it, using it? Is this house subject to inheritance? Do the wife and children have to pay anything to those who inherit from the deceased from the value of that house proportionally? If yes, what happens if they have no money to compensate them?
Now, in general, if a person dies, their house is an estate that they own. Unless he puts it, for example, gives it to the wife as a gift before he dies in his health. So if, let's assume he doesn't and he passes away and the house is in his name, the wife would own 1/8 and the children would get own that house, the remaining 2-1, assuming there are no parents. So in this case, the children, the wife would get all the money. Unless there are parents, they would also get the money. So if the parents own a share in that house, then uh, then they would own part of that house. So they can allow them to live in it for free. Or basically they would own, the wife and the children would own a certain share, and the parents would own, for example, 1/6 of the house or 1/3 of the house. And only in this case, if they wanted to take rent from it, then they would only get, for example, their portion of the house. Let's say and this is a bit complicated because you have a house here that's owned and you own a large portion of it, and a large portion of it, or a third of it, is owned by somebody else, and they want rent money from it. This would need some sort of counseling to see how much, how that would work out, so that the parents, for example, would get something from it. And in general, the parents should be forgiving of such things and let the wife and children live in it. However, if the house is sold, for example, it would be the inheritance would go to the wife, children, and the parents. So the only people that inherit, if all inheritors are there, are the spouse, the direct children, and the parents, the two parents. Allahu alam. Is there a correction on one of the questions I saw?
A
Yeah.
correction.
If there's a misunderstanding, please do write it in the comments, and we can check it out in the end. Bismillah. Some of these are not worded clearly as well.
Yes, yes, it is. It is difficult. Some of these questions are not worded very clearly, and it's difficult to follow up with the questioner. So, inshallah, Sheikh Ahmed is doing his best. I'm doing my best to read it as well. Bismillah. Next question. My husband and I have an account we opened solely for our children's education fund. In the Sharia, will this fund count towards our inheritance when we die, or can it be recognized as an education fund for our kids? Whichever case, do we pay zakah on it yearly or leave it for the kids to do when they are old enough to manage the account? You had mentioned that the daughter of your daughter does not inherit, really, even if she is the granddaughter from the son.
Okay, there's two different questions here. The education funds, if parents put it in their children's names and say only use this one for your education, then it would be the children's, and the person who executes the will can try to take note of that so the children can make sure that it's used for their education. However, if it's in your name and it's in your ownership and in your bank account, then it would be inheritance. So what you would want to do in that case is put it in your children's name and recommend for them that to only use this for your college education. But it cannot remain in your property and in your name and expect it to not be inherited. So it has to be given to the children and put in their name. And you can have somebody, for example, execute that from those who will execute the will. Yes, whoever owns it will pay zakah on it yearly. If you own it right now, you'll pay zakah on it yearly. And if the children own it, if they're young, you can pay zakah on their behalf. And if they're old enough, they can pay zakah for themselves. So even if a child has $100,000 in the bank in their name, zakah must be paid on it yearly. And the person who's in charge of that child would be responsible for doing so. So
Okay.
zakah is not delayed. And then if you mention the daughter of your daughter does not inherit, in general, the daughter's daughter does not inherit unless there are no normal inheritors, which in that case, for example, the daughter's daughter or the mother's sister might inherit in certain cases. But in general, they're not from those who inherit. And even if she's the granddaughter from the son, the son's daughter does inherit. Bintu libin, the son's daughter does inherit with certain conditions. So, for example, if a person left one daughter and his son's daughter and his son's son, the daughter would get one half, and the two grandchildren would get the rest 2-1 if there's nobody else. So in certain cases, yes, the son's daughter will inherit if the conditions are met. Allahu a'lam.
Okay, the next question. What about the non-Muslim heirs? If one is a revert with the rest of the family as non-Muslim, is it still limited to 1/3?
Yeah, according to the majority of scholars, the Muslims do not inherit from non-Muslims and vice versa. However, and in that case, we'll see of up to 1/3 can be given and taken. Allahu a'lam.
Can a trustee or executor be a female, or does it have to be a male?
Now, it can be a female. We mentioned that it's a Muslim, sane adult who's trustworthy, whether they're male or female. They can be the executors of the will.
Okay. Next question. Regarding prohibited wills and no greater than 1/3 of wealth to non-heirs, can you please clarify again the case for single Muslims with no dependents and well-to-do, rich parents and siblings?
The question is not clear. Yeah, in general, we mentioned prohibited wills like giving it to haram causes, things that are prohibited in Islam. We mentioned that that people who inherit cannot take from the will, and it can only be validated if all the other inheritors agree. As for non-heirs, they're allowed to have up to 1/3 of the wasiyah, which is after paying off a person's debts and their funeral expenses. Okay, the case for a single Muslim with no, meaning she has no husband, for example, with no dependents, I'm assuming that means no children, and well-to-do rich parents and siblings. In that case, if the parents are Muslim and her siblings are Muslim, the father and the mother would inherit only, the siblings would not if the parents are there. That's if they're Muslims. If they're not Muslims, then as we mentioned, the inheritance laws we follow as is, and anything, if there are no inheritors whatsoever, then a person can give in wasiyah up to 1/3 and even the whole wealth if there's no inheritors. So I'm not very clear on what the situation being asked is regarding the parents and the siblings. So if there's only parents and siblings and they're from the same religion, then they would inherit. The mother would take 1/3 and the father would take the rest, which is 2/3. The siblings wouldn't get, except if she left 1/3, she can leave up to 1/3 to the siblings, assuming they're all Muslims. And as for wasiyah, we said 1/3 is for anyone who does not inherit.
Okay, next question. Is it permissible to leave all your wealth as a waqf to a masjid?
No, a person is not allowed to leave all their wealth as a waqf to the masjid. They have up to 1/3 after paying off their funeral expenses and debts to give as a sadaqah or as a waqf. A waqf is a form of sadaqah. And the remaining has to be split amongst those who inherit. So if the person has children and a wife and parents or anyone who inherits, we follow the Islamic rules of inheritance. So the waqf, a person can give up to 1/3 as a waqf to the masjid or to any permissible charity. And only in the case where there are no inheritors or the inheritors agree to put all of the money as a waqf and they don't want the money, in that case, it would be permissible.
Okay, next question. In the US, a spouse, a wife, automatically gets the inheritance, the retirement funds, the house, the pensions, etc., and keeps it till her death before passing on to her kids. The logic is that she has equal rights to a man's income and that she needs to be supported after the man's, meaning her husband's death. What provisions in Islamic laws of inheritance address such a scenario?
Allah subhanahu wa ta'ala gave everyone the right in Islam. So the wife gets 1/8 if the husband has children, and she who inherit from him, and the uh, uh, or 1/4 if there are no children. So in this law, they only give full rights to the wife. In Islamic law, there are rights for the parents and rights for the children and rights for the wife. And this shows us the perfection of Islam. Allah subhanahu wa ta'ala gave everyone the right. As the Prophet sallallahu alaihi wasallam said, Inna Allah a'ta kulla dhi haqqin haqqa. Allah gave everyone who has a right their specific right. So once we know that, then the wife has to, and the children and the family have to follow the Islamic law, and the husband should do what is necessary before his death to follow Islamic law of inheritance and wasiyah. And inshallah, this was the kind of the whole point of this, is how can we be able to follow Islamic law and at the same time make it legal where there's no legal barriers or any legal problems. Barakallah fikum.
Okay, next question. What about a person who earns a lot and gives most of it in charity? He has very little property because he does not keep the money to himself. Can his charities be limited because his heirs will not get anything or very little if he continues to give most of his income in charity? Of course, that means during his lifetime.
A person is allowed to give in charity as long as he takes care of his obligations. So, for example, if he pays off his zakah, and I'm assuming this such a person would, and he pays off his children's expenses and his wife's expenses, whatever remains, he's allowed to give in charity. When can a child complain, or when can, for example, the wife complain if if the person's giving in charity or spending the money, or not giving them the money for their needs? In such a case, yes, the wife would be allowed to take from her husband's money for her and for her children what they need. So the Prophet ﷺ was asked by a woman that her husband does not give her and her children, that he's stingy and he does not give her and her children what they need. So the Prophet ﷺ said, take what you and your children need from his wealth bil ma'ruf. Like basically, she asked, I have access to his wealth? Can I take it? She said, take what you need, and for you and your children bil ma'ruf. Basically, what is customary? Take what you need based on the customs of that society. So without taking more than that, and do not deprive yourself from your rights and from your needs. So if the father is taking care of the children financially, and he's getting rid of and he gives the rest of his money in charity, then the nobody can complain about that. And we ask Allah subhanahu wa ta'ala to bless this person and his entire family for his good. But if a person should be careful not to give money in charity and let his children and his wife and his parents, for example, those he's financially responsible for, start begging people. or not give them their rights because they have an obligatory right. Only in this case can the children, for example, and the family members step in and say, he's not giving us our needs and he's giving all of his money in charity or the majority of it. In such a case, yes, they can complain to a judge, for example, or uh, the children, the wife can take what they need from uh, for their expenses, for their necessities. Allahu a'lam.
So Sheikh Ahmad, so you mentioned about the husband providing for the needs of the family as long as he's providing for the needs of the family. So a question may come in the mind that, okay, there are current needs and then there are future needs, you know, the future needs of what would be needed by the family after the husband's passing. So does the family have a right to future needs also, where this idea of the will, what is being left for us in wealth after the husband passes away, the future needs of the family? Is there a right there for the family?
No, once a person's taking care of his current necessities or the needs of his dependents, such as his wife and his children, he's paying the rent for the house, and he purchases the food that they need and gives them their clothing and pays for their normal expenses, school expenses. He's free to do whatever he wishes with the rest of his money. And they cannot say we're going to need savings in the future and we fear the future. They're not allowed to tell him, no, do not give in charity. They can advise him, leave us some savings, but they cannot stop him from giving in charity. However, a person must start with the obligatory charity or the obligatory financial obligations towards his family before giving in charity. After a person takes care of the current financial obligations, then uh, there is no problem. But a person should also be smart. They should not give away the majority of their wealth, and he knows, for example, in a month that he's going to have to pay, for example, the school tuitions, and then he won't be able to pay for school tuitions or the rent for next month. So a person uh, has to be financially responsible. So for his current needs and for the needs that he knows are coming up, but they cannot just say, okay, we want in 10 years to have like a lot of money in the bank, so don't give in charity. That's not up to them. A person is allowed to, once they're taking care of their financial obligations, to do what they want with their wealth. But they should also keep in mind the children and whoever he's financially responsible for, by not giving too much away in charity, so that the children do not result in begging people or do not struggle because they are more worthy of his charity. So even the money that a person spends on his wife or his children or his parents, if they're in need, it's considered also a charity. And if a person has the choice between giving charity to a stranger and giving charity to a poor or needy relative, then the relative is given preference. As for the children and the wife and parents in some cases, then this is an obligatory nafaqah, which takes precedence over all charity. Allahu A'lam.
Jazakallah khairan. Next question. If you have a son and a daughter, will both kids have half of your estate after debts and nothing given to anyone else?
Okay, if there's a son and daughter, normally they'll get the son will get 2 shares and the daughter will get 1 share after the debts are paid off and funeral expenses, assuming that there's no wasiyah. But if it's just the son and daughter, that's the case. But if there's a spouse or there's parents, then they would also inherit. So if there's only a son and daughter and there's no parents and no spouse, then the son would get 2 shares and the daughter would get 1 share after debts and funeral expenses are paid off and after the wasiyah of up to 1/3 of the remaining.
Okay. Inshallah, after this question, we have another about 18 questions for Sheikh Ahmad. These are from the last webinar, and then we'll move right into the questions for Brother Siraj, inshallah. So this question: if parents did not leave a written will and the children agree to give their parents' property to charity, would that be considered a sadaqah jariyah for the parents?
So as soon as the parents pass away, after their funeral expenses are paid off and their debts are paid off, and they don't leave a wasiyah, whoever inherits gets their share automatically, and they're allowed to. So assuming that there's no other people, there's no other family members that are inheriting, if it's all for the children, that's their money now automatically. They can choose to put that money as a sadaqah jariyah for their parents on their behalf, and they'll be rewarded for that, and their parents will be rewarded for that. Or some of the children will decide, I'll keep half of my share and give half as a sadaqah. They can do, each child has the full they're allowed to make the decision that they wish without being forced by anybody. Each child will have a portion of inheritance, and they can decide whether they want to keep all of it or some of it, or give it as sadaqah jariyah, either all of it or some of it. So if they all agree to give away their shares, they're basically donating their share for a sadaqah jariyah. Just make sure that there's nobody else. Everyone gets their inheritance, and everyone has the freedom of choice and will to keep all of it, or to keep part of it, or to give in charity for the parents.
Next question. What if you receive an incorrect higher amount of inheritance? For example, a father has 2 daughters and 2 sons, and he directs that all of his kids get equal amounts. If you are the daughter and now you have received a higher amount, what are you supposed to do?
So in such a case, we hope it's, inshallah, based on an ignorance of not knowing the Islamic rulings. Whether it was based on ignorance or not, the Islamic ruling would be that each person gets their appropriate share. They would have to redivide the estate properly. So they would get together and figure out how much each person took, and what is required to give each person their equal share, where the sons get 2 shares each and the daughters get 1 share each. And if there are any other people who inherit from the father that did not get their right, for example, a spouse or his parents or any, then in such a, everyone has to get their full right, even if some people incorrectly took a wrong share, whether they took too little or more than their share. Allahu a'lam.
Why does the daughter of the daughter not inherit?
Allahu a'lam. Allah subhanahu wa ta'ala mentions those who inherit from the children, and from the children's children, it's either the son's son or the son's daughter, based on the sunnah of the Prophet sallallahu alaihi wasallam. The daughter's daughter will not inherit from the normal people who inherit. She will inherit in certain cases if the normal people who inherit are not present. So for example, if a person dies and he only has, and he has a daughter's daughter, and for example, the mother's sister, both of them normally don't inherit, but if those are the only people he left behind, the daughter's daughter would be considered like a daughter, and she would get 1/2, and the mother's sister, for example, would be considered like the mother, and she would get 1/3, and then they could and so forth. So there is a whole chapter in fiqh called mirath dhawil arham, or tawrith dhawil arham, where the normal inheritors are not present. Then other family members who normally don't inherit will start inheriting in certain cases. Allahu a'lam.
Okay, just a comment about getting confused for those of us, I think all of us or most of us, who are not so aware of inheritance law and all of the issues related to it from the fiqh point of view. I think it's natural for us to be confused at points, and so Sheikh Ahmad did mention about how deep this subject is when he gave the webinar last time. People do entire doctorates in these areas, and he himself, spent many years studying these matters. So inshallah, please, our noble attendees, don't be frustrated if you aren't able to understand or follow some of the questions or some of the answers. And inshallah, our responsibility is just to depend on the people of knowledge to go into some of these more complicated matters and to these into the details. So inshallah, Sheikh Ahmed is trying his best to simplify everything and to explain everything in a way that we can understand. So jazakumullah khairan for everyone's patience. The next question.
Just real quickly, in a nutshell, if people are left to split their money amongst whom they wish, they will give certain children that they prefer more, or certain people that they prefer more. But in Islam, Allah subhanahu wa ta'ala chose who are the relatives that inherit, and when do they inherit, and how much they get. Sometimes we can try to withdraw all the wisdoms and realize what the wisdoms are behind it. But in the end, we know that Allah subhanahu wa ta'ala is Alimun Hakim. He's the most knowledgeable and the most wise. So all we need to do is learn, who does Allah subhanahu wa ta'ala want, how did he split our inheritance, and what are the rules, and who did he give priority to. So for example, the daughter's daughter will get in certain cases, but in general, she's not from the normal inheritors. And even, for example, the mother's sister, but the father's sister gets in certain cases, and the mother's mother might get in certain cases if there are no normal inheritors. So yeah, it is a deep subject, and we will not be able to explain all the details and the wisdoms behind it, but we just learn what Allah subhanahu wa ta'ala commanded, and we try to see, we can try to extract the wisdoms, but we just need to know who inherits, and who has been given priority, and how much does each person inherit, and we submit to Allah subhanahu wa ta'ala's commandment. And I'm sure all of us here realize that, but it's difficult sometimes to explain the wisdoms, the intricate wisdoms of Allah's law. And it's not easy to be able to mention why this person inherits this much and why that person doesn't inherit that much. Allahu alam. So a lot of this Islamic law of inheritance, once we know it's from Allah and His Messenger, we don't ask. We can try to extract wisdoms, but we don't make that. We fully submit as believers to the law of Allah subhanahu wa ta'ala, knowing that it's the most wise, even if I myself don't know why it is how it is. Allahu alam.
If the wife died and the husband inherits property from the wife, this couple has no children or parents. The wife left behind 3 sisters and 2 nephews. After the husband's death, who will get the property? The husband left behind 1 brother and 3 sisters and many nephews and nieces.
Okay, in such a case, we cannot answer this specific question as is, because it needs to go to either a judge or an imam who looks at the situation completely, who inherits and who does not inherit, if there are any, or if the conditions are met, and there's nothing to prevent from inheritance, because these questions sometimes are lacking full information. So these specifics, all the specific situations, I recommend everyone who has a specific situation of how to split their estate to go to somebody of knowledge to look into it, and to ask about their specific situation. In general, I can tell you, in general, the husband gets 1/2 if there are no children from left behind from their wife, or 1/4 if there are children. Now, I cannot tell you more than that because I don't know who else is in the family. No children, no parents. But is there anybody else? I don't know. There could be other people who inherit, for example. If the wife died, it could be her father, it could be her grandfather, it could be her brother. So I cannot really answer this question without more information and in detail. Allahu a'lam.
My mother passed away without a will. My brother, who is the only son, owes my mother a loan. He is now claiming that she forgave him, but we have no proof of that. What should we do in such circumstances?
Okay, obviously, this is why if there's any loans, that they should be written down, and if they're paid off, they should, and if they're paid off, there should be proof for that. So if there's proof that there's a loan and there's no proof that it was paid off, it becomes a burden on the person who paid the loan to prove it. So in general, for example, either the person can testify to this, or that he can have, for example, two witnesses, or that person can swear in such certain cases. I would take this case to an imam or a local scholar to look into this situation. Or if you want to give him the benefit of the doubt and believe him, then you can do so and consider that that he's saying the truth and the mother forgave him. But in general, with loans, a person should write down these loans, and if they're paid off or a person forgives the loan, it should be documented or well known so that these situations do not happen. Wallahu a'lam.
What if you don't get along with a sibling and don't want to leave them an inheritance?
Now, the issue is getting along and not getting along has nothing to do with inheritance. As long as a person is a Muslim, if a person dies, whoever inherits, and whoever the wasi is written for, the wasiya is given up to 1/3, and the inheritance goes to the children, whether a person likes that person or not, they had a fight with that person or not. It's not in our hands. It automatically transfers to the inheritors after they pay off their funeral expenses and their debts and the wasiya of up to 1/3. It automatically goes to those who inherit. Now, I don't know if the sibling will inherit or not, but I always advise all the siblings to fix and amend all the problems between themselves and not to have animosity or hatred towards one another, and try to forgive one another for your shortcomings and mistakes. It's a short life. Once a person dies, it's going to be their grave. They don't want to carry the burden of oppression, of animosity and hatred that they had towards their own family members. Wallahu a'lam.
How does this work, inheritance, in a polygamous marriage where the man has more than one wife?
More than one wife, they would all share that 1/4 or the 1/8. So we said a wife gets 1/4 if her husband does not have children, any children. If it was more than one wife, they would all split that 1/4 equally. And assuming that they're all Muslim. And if it's 1/8, let's say the husband dies and he has one or more children, and the wife and he leaves behind more than one wife, they would all share in that 1/8 equally. Allahu a'lam.
Okay. What about material things like jewelry, cars, etc.? I think we read
We
that.
mentioned that. Yeah, it's part of your estate and it's split as inheritance.
Okay. We can't take from the inheritance of non-Muslims. What if she left it in her will?
If she leaves a wasiya, a person can take up to 1/3 from a non-Muslim.
Okay. Please share the ruling or the guidelines for one wife as a widow without children with the deceased husband. Husband has left two parents and multiple adult siblings.
Again, I cannot give specifics unless I know the full situation. If a husband left and he has two parents and multiple adult siblings and a wife, the parents will get, and he has no children, the parents will get, for the wife, first of all, will get the 1/4 if there are no children. And if both parents are alive, they would get, the mother would get 1/3 because there's no children, and the father would get the rest. And the siblings would not get anything unless he left it for them in the wasiya, because the father would cancel out the siblings. That's it. So a person dies, a husband dies, and he leaves one wife, two parents, and no children. In this situation, it's clear. The wife would get 1/4. We're assuming that they're all Muslims. The wife would get 1/4. The mother would get 1/3. And actually, there's multiple adult siblings here. The mother would get 1/6 if there are more than two siblings. The mother would get, if there are more than two siblings, the mother would get 1/6 in this situation, according to the majority of scholars, and the father would get the remainder. Father would get the remainder. Wallahu a'lam.
Okay, as an executor, if she adopts a child, what does she need to do when writing her will to bequeath to the adopted child?
If she adopts a child, that child is not her real child, but it's a person who she's taking care of. That's what it is Islamically. It's not that that person becomes a true child where they carry the same, for example, the name of the person's father. That he, if he, for somebody adopts somebody, he does not take that person's name. You won't call him, for example, Zayd ibn Abdullah. If Abdullah adopts Zayd, he's not called Zayd ibn Abdullah. He keeps his name, and for example, an orphan that he's taking care of. That's what it is Islamically. So he would not get from the inheritance. However, he can get up to 1/3 of the wasiyah, and we explained in detail last class regarding the wasiyah and how to legally give somebody in their wasiyah.
What should a simple common will have in it? Is it okay just to say, please follow the Islamic law following the Quran and Sunnah for my will?
In general, if you're not living in a Muslim land where they follow Islamic law originally, no, you have to be more specific than that. As we mentioned, Brother Siraj also mentioned, to give as much detail as possible, or to leave it to somebody who will execute the will based on Islamic law, somebody trustworthy. If you get the My Will and Testament book by Sheikh Muhammad al-Jibali, he explains it all and he gives a sample will that you can follow as a guideline. Likewise, mywasiyah.com will, if for a charge, you can have that person create an Islamic will and deal with the inheritance and wills and the will that you want to make Islamically correct and legally binding.
Is a deceased salary subject to inheritance distribution?
Anything that a person owns is subject to inheritance distribution. So once a person has wealth from their salary, that's automatically their wealth that would, once they die, it would be part of their estate, which would be given first to funeral expenses and paying off their debts. And then we'll see up to 1/3, and that whatever remains after that is inheritance.
Okay, so this would also apply to pension, right? A continuing pension from a company for one of the
Right. So any investment or pension or retirement plan would be part of a person's inheritance that would go to those who inherit based on Islamic law.
Okay. If someone's son has mental health issues, would it be okay to change the inheritance? For example, a wife receiving the majority and splitting between the son and the daughter.
No, it's not allowed to change the inheritance. Each person will get their share. If a person dies, the wife will get her share, and the children will get their share, and the parents will get their share. And even if that person is insane, that money will be in his name, and basically they can be taken care of from that money, assuming that there's nobody. If the father is not there who's obliged to pay for the children, he can be taken care of from that money if he left behind money. So the inheritance does not change. Once a person dies, the inheritance does not change. However, if a person is healthy and they want to give more to one child for expenses based on need, that's okay. Or he can give more money to the wife to be able to take care of the children. That's also okay.
Do I understand correctly that during their life, parents can give money in different amounts depending on the children's needs?
Yeah, absolutely. Because if one child, for example, is in college and the expenses of college are more, then they will get more money for their college expenses. And if a person has more medical needs, they will get more money for their medical needs. Where do they need to be equal? In gifts, where it's not for a necessity. So when the children have necessities, each child will differ based on their age and their circumstance and so forth. So the parents will have to be equal in giving their children what they need. But past their needs, we're talking now about gifts. In this case, they have to be equal.
You mean during the lifetime of
during
the...
their lifetime. During their lifetime, it's either what you're paying for a child is a necessity, an expense, and a necessity, or an emergency and so forth, then each child gets what they need. So for example, one child's school expenses are $1,000, the others might be, for example, $200. So we do not have to equate in this sense. Somebody might have medical needs and will need, for example, $500 a month, and everybody else is healthy. They don't need that money. So it's all based on each child's need. The parents spend based on each child's need. However, when it comes to things that they do not need, that child does not need, for example, a PlayStation or some sort of game. So if a parent is not allowed to, for example, gift one child on Eid something and not give the other children the same amount.
Okay. Is it permissible to leave a stipend or pay fees to the executor to manage the estate?
In general, it is okay to pay a stipend or fee for somebody to do work for you. However, regarding this specific situation, how it would work Islamically needs more consideration and research. Inshallah, I will look into it and try to see if there's a way to answer this question. In general, there's no problem in this, but the only issue is since this is not going to happen anytime soon. For example, this is called an ijara, where it's a wage for work. It's kind of like a rental contract where you hire somebody to do work for you, right? So because it's not any time in the near future and it's unknown, it becomes a problem. A person is allowed to leave up to 1/3 as a donation, but the problem is if you make a wage for that person, that 1/3 is not guaranteed. So for example, if somebody dies with $100,000 and the executor realizes that the person has debts of up to $100,000, then nobody's going to inherit and there won't be any wasiya in that case. So I need to see how is it possible to leave a stipend or to pay the fees of an executor if it's something that did not occur yet. If you were to hire somebody to do a certain work for you now, there's no issue with it. But since it's going to happen after death, and this is a wage that should be guaranteed for that person, it needs to be looked into on how to do it properly and Islamically, where it would not be unknown and uncertain or a risk. So I'll leave this inshallah for further research. Wallahu a'lam.
For people who work in the US, basic life insurance is compulsory. Can that money be used for burial purposes, or should it be given away to a charity with no reward coming from it?
I looked into this issue, that this is not true, that life insurance is not compulsory. A person does not have to take life insurance. However, with life insurance, there's different types of life insurance. When the company itself or the government or any entity decides to give their employees something monthly, put it in a fund for them so that if they, for example, pass away, that money will be given to their family members. In that case, where a person is not paying for life insurance and it's something kind of like a charity, this is fine for a person to take, and it would and it would be it would be part of a person's estate, and it would be used to pay off their debts, funeral expenses, then debts, and it can be given as a wasiya of up to 1/3, and the rest of it would be inheritance in the case where a person did not purchase life insurance or did not spend from their salary. In the case where a person purchase life insurance, the normal life insurance that is not Islamic, and or they did so willingly or ignorantly, or they were forced to doing so, they would not be allowed to take more than what they paid. So for example, if they paid monthly a total of $10,000, they would not be allowed to take more than that $10,000. So if the company took from them monthly, or they paid monthly willingly, then they cannot take from that life insurance more than what they paid. So if they paid $10,000 and they received, for example, $100,000, that extra $90,000, if it was forced on them, they should get rid of that money, and the family should get rid of that money and give it to the poor, for example, to get rid of this haram money, because purchasing life insurance by the standard conventional life insurance is not allowed, because it's based on there's risk in it and it's a gamble, and those are the main two reasons for it, and it's money for money, which is a form of riba. However, if there is an Islamic life insurance where it's based on completely Islamic law, and the basically scholars, reputable scholars, consider it to be halal, in that case, it would be allowed for that person to take that money. But usually this is not, when you're talking about life insurance in the West, it's usually the conventional life insurance, which would not be allowed to take. A person would not be allowed to take more than the money they paid for, except in the case where it was given to them as either a gift or as for their services, and it was not something based on compensation where they paid for that life insurance. Wallahu a'lam.
Okay. Coming to our few final questions for Sheikh Ahmed. The clarification required when distributing gifts to your children, combination of sons and daughters. If you are alive, equal distribution was my understanding. Is that correct?
Yeah, the majority of scholars say equal distribution. And Imam Ahmad, rahimahullah, and his madhab say that it should be the fair distribution is what Allah subhanahu wa ta'ala mentions in his book. And Wallahu alam, the stronger opinion is the majority opinion, that it should be equal distribution if it's a gift in a person's life. But after death, this is where the laws of inheritance apply. Wallahu alam. Even though both opinions are strong, and if a person followed a scholar who took the other opinion, either opinion, it would be fine, as long as you follow a trustworthy scholar. This is one of those valid differences of opinion. If a person follows the majority opinion of equal distribution, then this is a very valid and strong opinion, perhaps a stronger opinion. And if a person followed the other opinion of Imam Ahmad and the Hanabila, then there would be no problem in this. Wallahu a'lam.
Okay. So that was your last question. Sheikh Ahmed, we have just a follow-up question from a few questions ago about the life insurance. The sister is saying, if life insurance is haram, does 401k plan fall under the same category?
No, 401k is a type of investment, so it would need to be, in general, a person should choose halal investments so that their 401k is the returns from it are halal. So it's a type of investment. It would follow the rules of business investments or and so forth. So a person is not allowed to, for example, purchase bonds, which are loans from the government, and a person would not be allowed to invest in companies that revolve around haram products and services, and they should be only invest in halal companies that provide halal products or services. And in general, the issue of stocks or even 401ks, you have to look at the return from it, the profit that's made. Is there any of the income coming from haram sources? And how much is it, so that you can get rid of that money? And sometimes you have the option of choosing what you want to invest in, and sometimes you don't have to. But I refer people regarding 401k and investments, I refer them to consult Sheikh Joe Bradford. He has a website, and he does business consultation. He answers questions regarding 401ks and investments in general, how to do halal investments, and how to figure out what's completely halal and what's has some problematic issues Islamically. So I would refer you to him. Inshallah, you can just type his name and you'll find his website, and get consultation from him regarding 401k and your investments, and if you want to invest in whether stocks or you have specific questions related to 401k, then I would refer you to him, because this is his specialty. And yeah, legally and the ins and outs of it, he specializes in this. So I would refer you to him, inshallah ta'ala. Joe Bradford.
Is that my wasiyah, Sheikh Ahmed? Is that
He has my wasiyah.com, and he offers also consultations for investments, and he'll answer questions on 401k, and he has lectures and articles on these things. So I would refer you to him too. If you have a specific question, you can make an appointment for a consultation.
okay? So that was the end of Dr. Ahmed's segment. Inshallah, he'll still be with us for the remainder of the program, but we do need to switch over to the questions regarding U.S. law with our dear brother Siraj Sohail. But before we get into those questions, just 1 or 2 minutes, I wanted to make a few important announcements, inshallah. And if you pay attention to what's on the screen now, just a few things, brothers and sisters. Dar-us-Salaam, the mission is really to educate the community, to remind them of Allah subhanahu wa ta'ala, and to establish a community project that can serve as a model of putting Islam into action here in the United States. So we, of course, get funding through your donations. And for those of you, alhamdulillah, especially those of you who have been donating over the years, it would be wonderful for you to continue that support even after your death. And you can do that by giving us a planned gift. And if you would like to put Dar-us-Salaam in your will, or give us some kind of a planned gift, whether it's property or other type of assets, to put that in your will, then you can definitely give us a call at the donor care office at 301-982-2061. And we have scholars like Sheikh Ahmed and other professionals in this field who we can direct you to, who can help you to do that. Of course, we can be involved in whatever process you do. Or you can also email us at yourlegacy@dar-us-salaam.org. Yourlegacy@dar-us-salaam.org, inshallah. Also, brothers and sisters, there's another way you can give to Dar-us-Salaam in your lifetime or after it, or with used cars. We have a Cars for Jannah program. You could go to carsforjannah.com, and you can easily donate your used car, working or not non-working, and that the money from the sale of that car, we will take care of it all. It's very, very simple. We can benefit from that as well. Also, I wanted to let you know, attorney Siraj Sohail, he is the general counsel for Dar-us-Salaam, our organization, and he also does a lot of work with inheritance and wills. He has given seminars. He works with clients directly on their wills and their estates. So, brother Siraj Sohail, Bismillah. The first question for brother Siraj is going to be, what does the bank do if you don't have a will with the money, the house, cars, etc.? And what if you have a joint account?
Assalamu alaikum. So how it works is, if one has a bank account, if it's a joint account, meaning that there's two people on the account, the account naturally, by a matter of law or just a process, passes on to the person who is surviving, the surviving person on the joint account. If there is an account that's not joint, they then look to see if there's a payable on death beneficiary, meaning that someone will take the funds that are in the account upon the passing of the owner of the account. If there is no joint account and there's no payable on death beneficiary, then to have access to the account, a court case would have to be opened to allow for the executor or for the person who's managing the estate to have access to the account to gather all the assets and distribute according to the will. According to the law, if there's no will.
Okay. Next one, depending on the U.S. state, if there are payable upon death, PODs, and or beneficiary forms in place on assets, can the deceased assets still end up in probate? And Siraj, can you just very simply explain what does the term probate mean?
Okay, so probate means the court process by which someone's estate or someone's assets are distributed upon the passing of an individual if there is no beneficiary on there or if there's no trust. So basically, if you have property or you have assets that are owned just in your name and don't have beneficiaries, then one would have to go to the court to have the judge or have the court designate someone to manage the estate on behalf of the person who has passed away. So the question is, depending on the state, if there are payable upon, okay. So if there are payable and death beneficiary on place, then those accounts or those assets, they will naturally pass down to the person who is listed as the beneficiary or the one who is going to obtain ownership upon the passing of the owner. The assets still can end up in probate if for several reasons. One, if there's property, you can't have payable and other beneficiaries on property. So if it's probably just in one person's name, one would have to go to probate to have that resolved. Or if there's if other ways which a case can end up in court or in probate is if if someone questions the payable and beneficiary and says that this was done unfairly or unjustly. But generally speaking, having payable and death beneficiaries is a good way to minimize one's risk or one's chances of their case or their estate ending up in court.
Okay, next question. Should a will document list all the detail of assets, bank accounts, property, etc.? And if so, how often does it need to be updated?
All right. So one does not need to list the assets, meaning bank accounts, property, on the actual will, because things change. People open bank accounts all the time. They might buy or sell property. So it's hard to keep track of that. But if one does, then it just needs to be updated as things change. Also, we also recommend that Islamically, because depending on who's in a family, numbers, the distributions can change. If someone has an addition, a child, or someone passes, it's always good to update the will at that point too, to make sure that the distributions make sense. But they don't need to be, the assets don't need to be specifically listed on a will. It's good to have a list of assets just so that the person who is the executor can manage and know where all of one's assets are, kind of an inventory, but it's not necessary for the validity of a will.
So in other words, Siraj, so you don't have to say my bank account 5729, whatever. You just say what, like my bank accounts or my all my assets, like that?
Basically, most of them say my assets. So how a lot of wills or estate plans are drafted are that after one's debts are paid, after one's funeral expenses are paid, there's a certain amount of assets, right? You have $10,000 in one bank account or whatever you have. The executor or the person who's managing it will gather where all of that is and will say half, if there's two sons, half goes to son A, half goes to son B. Things change on a regular enough basis that listing the assets, it might not always be the most accurate, the most current, and that's not the most effective way. But it's good to have a list. We do have clients who come to us after the fact. A son will come and he'll say, I don't know where all my father's accounts or properties were. So having an inventory, having a list is just easier for administration and for just general management.
Okay. Next question. The following statement is part of an Islamic will form. Quote, I direct that no part of my estate shall be bequeathed to any non-Muslim relative, whether this relative is blood kin or in-law, spouse, parent, or child, with the intent to prevent inheritance of any assets going to a non-Muslim family. However, is the term bequest correct if it is actually allowed for the Muslim to leave up to 1/3 to such relatives as a gift, bequest? Please clarify if there is a difference between inheritance and bequest in legal terms.
So in legal terms, looking at this question, the judges are not, the judge or whoever is administering the estate, if it goes to probate matters, they're not going to try to determine bequest or inheritance. This is considered to be disinheriting someone, meaning that you don't want for someone to take from your inheritance. That's how this would be interpreted. Language like this, it most likely will not be held up in a court of law, just because courts are very hesitant to determine who is or who is not a Muslim. So generally speaking, having vague terms like this, they don't work. If one wants to specifically disinherit someone for whatever reason, that they no longer a Muslim or they're not Muslim, they would have to be specifically listed out that you want for this person to be not take from one's inheritance. Otherwise, if it's a child, that child can very easily object to this particular language and try to get a portion of the estate. So this language like this, what it most likely would do would lead for a contest of the will, or someone saying this will is not a valid document, and that would just raise the cost of the administration and cause for more headache and more money used up in the process of trying to determine who gets what.
Okay,
But yeah, legally speaking, in the court system, this would be treated as disinheritment. I mean, you don't want any person that meets this requirement to receive any inheritance.
Okay, so that's something new to me personally. That if you don't want a relative to inherit, then you could list them to not inherit in your will.
Right. So if you have two children and you specifically don't want one child to inherit for whatever reason, legally speaking, you'd have to basically say, I don't want for this person to inherit, because courts, generally speaking, if one under the law, meaning if you didn't have a will, and someone was entitled to inherit, courts are very hesitant to not allow for that person to inherit. So you have to, in most states, in most jurisdictions, you have to specifically disinherit someone by name.
Okay. We have a real estate business with properties moving in and out of it. Can or how do we reflect this in a living trust?
So there are several ways of having this be managed or to fall under the jurisdiction or fall under your mandates in the living trust. One is that if you have a business, generally speaking, it's good not to do business just in your individual name. It's good to set up an LLC or some corporate structure for asset protection purposes. So if you have a real estate business just in your name, if someone slips and falls on that property, you become personally liable. But if you have a business set up, your liability is limited to the assets of that business. And what you can do is you can have your living trust as you being the trustees. In many jurisdictions, you can have the trust, basically the trust be a quote unquote owner of their property, because the trust, many times speaking, would be the husband and wife or whoever is owning that real estate business. So that's one way of doing it, is creating an LLC and having the trust be one of the owners of the trust. Whereas that way the trust will have ownership stake. So when one passes, the trust will manage that portion of the business.
Okay. Are Virginia and DC inheritance probate laws similar to Maryland? Can you give references for Muslim attorneys in Virginia experienced with wills and or estate planning?
So generally speaking, the probate laws are similar everywhere in the country, in that if one has a will or a trust, then then that's going to be the managing document, or the document which guides how one's assets are going to be distributed. If one does not have a will or one does not have a trust, and the courts have to get involved, then the distribution of who gets what is managed by the state. And generally speaking, they are similar. And I do have a list of a couple of attorneys in Virginia and Maryland. I can pass the name on to Minhaj, and there's a list. Those can be forwarded, I think, in email. That might be easier, I think, of their office. I'll just reach out to them and make sure that if people reach out to them, they have a heads up that they came from this program.
Okay, inshallah. What if I want to make a will or trust, but my spouse has no interest? Is there a way for me to do this?
Yeah, I mean, everyone has their own assets. Everyone has things which are specific to them. So whether or not one's spouse is on board, I still recommend one to create a will for themselves. Number one, you can clarify how you want to be buried in a will in many places. Number two, it's just good that your intentions are known, so that it's clear on what you want to have done with your assets, or with what you're leaving behind. So whether or not one spouse is on board, that doesn't matter, because a will is an individual document that everyone creates for themselves.
Okay. Living trust, is it just for children who are younger than 18 years old, or even for other ages? How important is it to set up a living trust? How much does it cost to set up? And if we have a living trust, do we need a will? We have a revocable living trust. The son is the executor of the estate. He does not know much about the jewelry. Can we put it in the trust that our daughter will take care of the jewelry in the safe deposit box to distribute? Is power of attorney part of the living trust, or is that a separate thing that one needs to establish?
All right, so there's several questions in here. A living trust, basically, that's a revocable trust. So that's a trust to manage one's assets, where you create a private document and you say, these assets that I have, they're managed by my trust, and I want for them to be distributed out Islamically, or you mentioned how you want them to be distributed out. So whether or not one has minor children, it's a good idea to have a trust if you have assets to keep to make sure that, inshallah, your case can avoid the probate process and spending money in the court and using up resources there. Generally speaking, to set up a trust, it costs a little bit of money. Many times starting at $200 to $2,500, depending on how many assets are involved, and it goes up from there. But it many times is worth it, because if there's many assets involved, if it ends up getting in court, you're looking at thousands more. So you spend a little bit more upfront to save more on the tail end. So if the son is the executor of the estate and he does not know much about jewelry, you can have co-trustees in a will or in a trust. You can have co-trustees. So you can have them both on there where they kind of work in tandem, so that they can work in their strong suits, because what they know about and what they're strong in, because legally speaking, jewelry and all that, those are assets which you do want to account for in your estate plan. I think Islamically too, that's something you want to account for. So that's not an issue to have that. As far as safe deposit boxes, you want to make sure that on the bank, it's clear to the bank individuals that your daughter, whoever it is, can access your safe account box. Many times we have clients come to us where that they have everything taken care of, but they didn't realize that they had a safe account in the bank. And for a safe account, we've had to open probate matters. It's just better to have that person specifically listed, so that you don't have to go to court to have a executor appointed to open that safe account, the safe deposit box. A power of attorney, that generally speaking, is when you create an estate plan, have a will and a trust. Lawyers talk to their clients about having a power of attorney. And what a power of attorney essentially does is that while you're alive, you appoint someone who can do whatever you can do. Basically, they serve as a puppet for you in many ways, that whatever you can do, this power of attorney, they can do whatever you allow for them. It's a very powerful document, so it's good to make sure that you trust the person you give the power of attorney to. And you don't need to have a full will drafted to draft a power of attorney. Many times you can just have that done individually if you need it for a specific purpose.
Siraj, a follow-up question on this. Do we need the same executor on the will and the living trust?
No, you don't.
Next question, and we only have a few more questions for Brother Siraj. I know we've come to the official the time given, but we're going to continue, inshallah, and finish these questions. Due to this pandemic, is there a template available to even ask our young adults to have a will set up?
So I think Ahmad mentioned a couple. One is the my wasiya. I've looked through it. It's a decent document. It's if one wants something which they can get online and taken care of, I still recommend sitting down with an attorney if there's assets in play, because the my wasiya language can be convoluted sometimes, but it's a good safety net to have, as opposed to having nothing else. And also, I think Dr. Al-Jibali's books, those also are something one can refer to. And I think many times masjids, they might have services available too if someone needs something quickly. So you can contact your Islamic Center also if they have a template or something. But my wasiya and Dr. Jibali's books are two good resources which are available.
Question, Siraj, about these template wills, like in these books or on websites. How closely do they need to align to state requirements or state language?
So it's better to have them align with standard, because most lawyers who draft wills, they have a pretty standard nomenclature, standard way of drafting wills. A lot of these ones which are available on the market, they don't necessarily follow the same pattern. So they become a little more complicated for judges to try to figure out and to try to interpret. They can work sometimes. I have seen personally, I know in Florida, where someone did use one of these wills which are available online, and the judge actually refused to follow what was in there on the grounds of public policy, because the son was getting a lot more than the daughter. So those are things to consider when you're using these documents, because there's this chart that said if you have one son and two daughters, this is what you want how you want to be distributed. And the judge was not in the mood to try to figure out who gets what, so we just said half and move on type thing.
Oh.
Yeah.
Are there any major legal U.S. considerations in wills, trusts, directives for an Islamic, not U.S. legal spouse? Oh, okay. A spouse, traditional, one wife, one husband.
So major legal considerations are that, legally speaking, there are certain protections which are available for a spouse, which you won't get if it's not a registered marriage. There are, now even in American culture, more people are living together without getting married. So what we recommend for people who don't have a legal marriage is that it's good to try to institute as many protections as possible, as far as if there's property, to jointly own property in the situation, to have joint accounts, to create basically a contractual relationship which can try to mitigate and minimize the risk or the harm of someone who's not legally married. Because in the eyes of the law, if one is not legally married, that person would really inherit nothing absent a will, or absent some sort of document which clarifies it. So you can put in there that you want such and such person to receive, if they're supposed to receive a quarter or 12% or whatever, you can put that in your will or in your document. But without that, they would have nothing that they would receive in the court of law.
Next question. If we make a will, estate plan at a lawyer's firm, for example, Brother Sohail's firm, what happens if Brother Sohail retires? Are you that old? Other partners at the firm who will take over our will, or will we need to go to another firm to update or make changes to our will or estate plan?
So how it works is, when you create a will, most firms, they'll sit down with you, they'll create the document, they'll have it get signed and notarized, so that becomes your legally effective and legally binding document. All firms keep a copy. They email you a copy and they'll give you the hard copy. So there's many points of contact where that document is located. At our firm, we do have two other attorneys who work with us. So yes, if things need to be changed or amended, we work with our clients. Just this week, I had two clients reach out to me who wanted to remove, I think, a guardian for their children, and someone else wanted to add a beneficiary or something. So yeah, we work with our clients if changes need to be made. Otherwise, the other attorneys also, they can make the changes, make the amendments, or just create a new estate plan. So it just depends on what one's wishes are. But yeah, if you go to a firm, more times than not, they will work with you in the future to try to make sure your wishes are met.
Siraj, when it comes to keeping copies of the will, the attorney's office may have a copy. The person whose will it is may have a copy. What is the function or the role of the county register of wills?
So that's another thing. You don't necessarily need to, but once you create a will, you can register in most states, in most jurisdictions. You can register your will in the register of wills, meaning you go to the clerk of the court and you give them a copy, and they'll put it in the record. So that's another place where it's located. The thing about that is that if things change, you need to go and you need to always give them an updated copy. So if one stays on top of that, they can do that. The one benefit of that is that it's foolproof, meaning that it's foolproof in that whatever is in there, there's no question that that's the document that you want to have. So for example, if you create a will on January 1st, right? And you register that, then you create something on February 1st that's amending that earlier will. It would be very hard for the legal process to accept the February 1st will, and they would most likely go with the will which is in the public record, or which is in the clerk with the court. So that's something which people can do.
Okay. The next question. So do you suggest that if a divorcee wants to remarry, a prenuptial document should be prepared to delineate what belongs to the woman before getting married to the new man?
Yes, I do actually recommend people creating prenuptial documents, whether or not they're a divorcee or they're getting married for the first time. Just statistically speaking, many marriages, they unfortunately do end in divorce. And we see many cases where a couple spend a lot of time and money in courts trying to figure out whose assets are whose. So you can put in your prenuptial agreement or in this document saying that I'm coming in with X, my spouse is coming in with Y, my stuff stays mine, your stuff stays yours, and whatever is incurred through the marriage, I keep whatever I earn, you keep whatever you earn. So it's good to have this document to save headache down the road, and also it does help with estate planning. But it's more so just a family law matter where it's a good idea for couples to think about.
Okay. Next one. How is the 401k or pension taken into account as part of the will or inheritance?
So 401ks and pension plans, when they are created, many times you designate, as I'm sure people know, payable on death beneficiaries. So whoever is on that payable on death beneficiary, whoever you designate, they will receive the proceeds of the 401k, the IRA, or the pension, whatever one has is for retirement purposes. Whoever is the beneficiary in that is the one who will receive the proceeds. And then after that, if they need to be distributed out, it's really upon that person to distribute it out. But legally speaking, whoever you put on that document is who has legal ownership of the assets or the pension funds.
Okay, next question. Can someone overseas, not a U.S. resident or citizen, be responsible for executing the will or assigned as responsible party for making decisions taking care of children?
So this goes to the issue of executorship and guardianship. For executorship, meaning the one who's going to manage and who's going to see through to make sure one's wishes are met in their will. Generally speaking, it's very difficult for someone who is overseas to serve in that capacity. If they're in the United States and they're not a citizen or resident, if they're not a resident, I don't know how they'd be here for a long period of time, but they don't necessarily need to be a citizen. That's not a concern. The concern is that they're here and they can take care of whatever needs to be taken care of. Someone being overseas would be very difficult for them to fulfill that role. And I know in many jurisdictions, I don't think they can. So you would need someone who is here. As far as guardianship of one's children, how the law assumes is that if there's two parents, if one parent passes away and the child's a minor, the surviving parent has guardianship and has the children become that person's responsibility. If both parents pass away and someone wants to designate someone overseas to be the guardian of the child, that's something which you can put in your will, and to try to make it work. It would be difficult in some ways because courts would be hesitant to grant legal guardianship to someone who is not overseas. So it's good to have someone who is here, but if there's no one who is here who can serve in that role, we have created documents where people are overseas who serve as guardians, and it was a little bit more complicated in the process to get that person to actually get the guardianship, but it's something which can be done. It's just more complicated and it takes more time.
Next question. Any idea how much Muslim funerals cost?
A lot of that depends on where you live. I know in Florida, in Orlando where I live, it ranges from $3,000 to $5,000 or $6,000. I think in Maryland also it starts around 3 and it goes up from there. So it depends on where you are. It's not unfortunately it's not something which is cheap. It does cost money, so that is good for someone to set aside funds for that, for just to make sure that their funeral costs can be met.
Another question, Brother Siraj. Can Brother Siraj's firm help create a will and living trust for someone who resides in Virginia, or do I need to find local Muslim attorneys?
You would need to find someone who is local in Virginia, because in a estate plan, having a will or trust is a legal document. It's something which is governed by laws. For a lawyer to draft it, they need to be licensed in that particular state to draft it. Otherwise, they can get in trouble for unauthorized practice of law by state bar authorities. So yes, you would need someone local. And I have a couple of people's names, inshallah, that are good and trustworthy. I can pass them on, inshallah.
Are there examples of Islamic wills that adhere to local laws that can be provided to the attendees?
So I think we mentioned the my wasiya and the Dr. Al-Jibali's one. Those are the ones that I know about. They're not the best as far as making sure that they would always be abided to. But if someone's choosing between having that and nothing, it's still a better option.
Siraj, just a clarification, are the wills, they have to comply with state or county level or both?
So it's usually state law. It's usually state law which determines, because the legislature determines what's going to be a valid document to have a will. So like many states require two witnesses to sign it. It needs to be written. The person needs to have the capacity to know what they're doing, and it needs to otherwise meet requirements. So those are state law things. As far as county level, there are procedural things which have to be met. Meaning that you have to, for example, in Florida, when we open a court case, you have to make sure that if there's a will, we submit the will, we submit the proof that the funeral expenses are paid. But there are certain procedural things which are county level, but overall they need to abide by state rules and follow basically county procedural steps.
Okay, and there's no particular federal component with regard to wills. Is that correct?
The only federal component is if, mashallah, someone's very, very wealthy, and there's an estate tax which they would have to pay. Under the current tax code for a single individual, I think it's $11.4 million. For someone who's married, for a married couple, it's $22 million. So if someone is leaving behind assets or an estate in excess of that, then there could be potential federal estate tax consequences. But other than that, there's no real federal law, which it's a federal laws which one has to worry about. It's more of a state law thing.
Okay. Are there examples of wills that adhere? Or did we answered this question?
Yeah, right.
Here's a follow-up. If I create a will through mywasiya.com, will it be held in the court of Maryland or Virginia?
That's something which I personally can't answer. There's many variables or many things to consider. So I can't answer that other than it's, you can draft it to them and inshallah it should, but you'd have to look at it in more detail and determine, but it should.
I'm wondering if there is a software out there to help with this matter, like TurboTax in tax filing, for example. So he's looking for, or she's looking for Turbo Wasiya. You just type in the information needed and get the layout of the distribution. It will be very helpful for Muslims.
So for distributions, for inheritance, I think there are inheritance calculators online where you can have a general idea that if you have one son and two, if that's what you're getting to, there are options available. So if you just go to Google and go to inheritance, inheritance.ilm summit, and there's IRTH. There's a few other ones which are available. But that's something which you can look into, and we use one of these, and I think it's IRTH. I think that's the one that we use, just to whenever we work with our clients to make sure that our numbers are accurate. And again, we in our firm we list people out. So for example, if I have a wife and 3 children, I will say my wife, should receive this percentage. My son, my daughter would receive certain percentages. As numbers change, a parent or a spouse, a child is born or someone passes, you need to keep your documents up to date. So that's just something to keep in mind. And you'll see that in the calculator.
Siraj, that was the last question, but I'm just gonna ask 2 more from the chat. Can Pennsylvania lawyer recommendations also be made available?
Pennsylvania, I'll have to ask. So there's a National Association of Muslim Lawyers. I'll put a question out there for Pennsylvania Muslim estate planning attorneys, and I'll see what response I get. Okay,
now this one here, I'll let this be the last question, inshallah. Just to be like a summary for you, so do the best that you can. What is the actual process of wills and inheritance once someone dies in the U.S.?
So the actual process of wills and inheritance when someone dies in the U.S. is, first, obviously the person is buried, right? That's the first part of it. wills can come into play if there is a question, or if there are non-Muslim relatives who will say that we want for this person, for example, to be cremated or not be buried Islamically. So you can put in your will that you, for example, you want to be buried Islamically, you want to have the ghusl, the washing, you want to have the funeral janazah prayer. You can have those things in the will, right? So you can have those things. So that's where it starts. Then after that, you know, if you have assets, if you have a car, if you have bank accounts, if you have a house, if you have properties, if you have a business, all of those things need to be accounted for, right? So someone should know where all those assets are, and then that person, you know, they will see if there's a will, right? So if there's a will or a trust, they'll go to that document and see what that person's wishes are. And then they will, if they need to open a court case, they will go to a lawyer, they'll file a court case, and they will enter that will into the probate matter, meaning that when you file the case, you'll say so and so passed away on such and such date with such and such family members, and they have a will. So once that is entered into, then the judge appointed the executor. The judge basically gives the executor legal rights to wrap up the estate, to reach out to banks, to reach out to property, you know, if one wants to buy or sell property, to sell property, all those things are taken care of through the executor. So once, then you have to create an account. You create an account in the estate of. So the assets go into the estate of account, and then they are distributed out once all the expenses are paid out. That's if there's a will. If there's a trust, it's much more simpler. If there's a trust, then you say in the trust privately that I have, for example, this house, this account, and the trust is the beneficiary. So then the trustee can get access to those and just distribute out. So it just depends on if you have a will or a trust. I recommend a trust just because it's a private document. It's done much more quicker, and it's just, you know, there's less stress involved. If there's a will and you have to open the court case, then there's just more steps involved. And the other thing that is a good idea is to look into having beneficiaries on the accounts that you have, so that person can just go to the bank. So how beneficiaries work is that, for example, I have a bank account and I say Brother Minhaj is going to be my payable and beneficiary. So what Brother Minhaj would do is he would go with my death certificate and go with his ID. The bank would take that, then they would say, okay, Brother Siraj has $10,000 in this account. They would give it to Minhaj. That would be Minhaj's, right? And then he'd be free to distribute it out or do whatever is in the document. That's kind of how the beneficiaries work. And so that's why it's easier to have a trust or beneficiaries. And I advise clients to try to plan ahead to avoid court process to the greatest extent possible. I don't know if that answers the question, but basically it starts with going to the court, opening a case, and going from there.
Okay, Sheikh Ahmad, did you have? I saw that you wanted to answer a question live. Did you want to do that?
No, sorry, that was a mistake. Those I want to answer live, I typed in the answer for them.
Okay, I'm looking at questions. My eye popped up. Someone says my son is 19. Can I sign him as guardian of his sister if she is 13 and my other son is 17? Yes, legally speaking, as long as someone is an adult, meaning they're above 18, they can serve as a guardian for minors. Legally speaking, yes. That just popped up in my side division right now. I know that we are running out of time, so people are free to go. There are some questions here I don't mind answering. Does a will have to be notarized during COVID? Documents should be notarized. If you're in Maryland, I know the government or the governor, Hogan, he made it much easier for e-notarization. So that's something you can look into. What is the actual process? I think I answered that. The Pennsylvania lawyer, YOC, I think I answered that. Okay. Virginia, we answered that. We don't need the same executor. Yes, do all inheritors or immediate family names be listed on the will so there's no confusion? Yes. So we recommend listing out inheritors by name and what you want for them to receive, so that there's no ambiguity. So for example, if I have a son Ahmad and a son Abdullah, I will say Abdullah will get 50%, Ahmad will get 50%, and then you list them out what the distribution is, and that's just easier for courts to have to deal with, and also for the trustee, if it's a trust, to know who's getting what.
Brother Siraj, with that though, let me jump in on that. When you specify how much each person will get, sometimes that can change before.
Right, so that's why it's important to keep it updated. But that still works better than having those if-then statements. If I have one son and two daughters, I want for this to be distributed out. I know that if it does have to go to court, judges, they're not keen on having to do all that. So by putting specific percentages, it's just easier.
I know it's easier, but what do you do in the case if that's, let's say you have, for example, two sons and you give them each 50%, they're the only people that inherit, and then one of them dies before that person. So technically he wouldn't be inheriting from him. Is there a way to put a disclaimer or
yeah, so there are disclaimers that if someone predeceases, so for example, in this case, Abdullah or Ahmad, in most wills, what they will say is that if one passes away, then the other person gets the whole share, or there's something called basically the technical, what happens is that if say you have in the legal document, if you have Abdullah and Ahmad and Abdullah passes away, then you would put in there that Abdullah's children or whoever will get their portion of it. So I know Islamic that's questionable. So what we do is we say that if someone passes away, they are no longer part of the distribution process.
Okay, because yeah, I could imagine a situation where he leaves for his brother something,
Yeah,
and then the wife, for example, has a child, right? Delivers a child before death. There are certain situations where the laws of inheritance will not stay constant. So
right.
just a way to keep that legally binding so that it's
Okay.
kind of flexible with the change in situation. Is there a way to say that the executor will basically change it according to Islamic law or no?
That is very hard to work because it shouldn't change. It should be what it is. And when you put the Islamic law in there, courts are hesitant to go with that just because a couple years ago there's a whole Sharia bill uproar and all that. So we try to keep it as vague, keep it as legal as possible, and not put too many Islamic terms in, just so that there's no point of attack saying that the courts are trying to interpret.
Without saying Islamic law, can I say I leave it to this executor so and so to give 1/8 to my wife if I had children, and X to this amount to my children?
We can have this. I know people are running that. You can, but the more ambiguity there is in a document, the less likely it is to be upheld.
Okay.
Okay, jazakumullah khairan to everyone. I'm just going to close out with after thanking our two distinguished guests, Dr. Ahmad Abdelwahab
Ahmad
and
is distinguished. I'm just here for because I was promised ice cream, I think, at some point. So
you owe me $10,000, by the way.
exactly.
And our dear brother Siraj Sohail, we really appreciate their time. They put a lot of effort into this. This is the second, second session that they spent time in, and they also looked over these questions. And they went over them and prepared some responses, or at least thought about them. So we really, really appreciate their time. May Allah subhanahu wa ta'ala make all their effort and their knowledge a blessing for them and for this ummah. Ameen. And we thank all of you for coming. And I just want to close out with by just reminding you about these upcoming events, inshallah. March 28th, this is the iMuslimah halaqa on marriage, how can you not, by Brother Safi. That's going to be open for both brothers and sisters. The Ruqya iMuslimah halaqa is actually only open to the sisters. So I just had to clarify that one is only open to sisters. That will be February 28th, later this month. And then Ansar al-Bir, our social services department, is going to be continuing giving out groceries to those in need, whoever is in need, Muslim or non-Muslim. So if you know families in need, please direct them. You can even come here to Bourbon Heights Elementary School and pick up some bags for those in need and deliver it to them, inshallah. And carsforjannah.com, that's your place. Whenever you want to get rid of that old ride, please park it in Jannah for good, and let it benefit our community and our Al-Huda school. And last but not least, we do have a facility for you to give a sadaqah jariyah, to put Dar-us-Salaam in your will. Just email your legacy at darussalam.org or call our donor care office at 301-982-2061. And with that, I'll close out again. Thank you for the sisters, the iMuslimah sisters, who did all the hard work of putting these things together. these will seminars. Thank you especially to Sheikh Ahmad Abdelwahab, Brother Siraj Sohail, and all of you for your patience. This is not an easy topic. It's a very important topic, but not easy. So thank you for your patience and listening and working with the question and answers today. And Jazakum Allahu khairan. سبحانك اللهم وبحمدك نشهد أن لا إله إلا أنت نستغفرك ونتوب إليك and Assalamu alaikum wa rahmatullahi wa barakatuhu.